Hello, everybody.
Right under the TV, that table.
Yes, motherfucker, I'm slapping the
Yeah.
fuck out of this ass next time.
Hey, who's using that kind of language?
Sorry,
Who was that?
Bobby.
Bobby, was that you doing that?
Yeah, I was cussing at myself.
You were saying you're calling yourself those names and you're gonna slap it yourself?
Yes.
I don't buy that. Well, we need to wait a minute. Deputy, are you with him?
Yes, Your Honor.
Who was he talking about slapping?
The jailer, the night he set off the smoke alarm.
Well, it's not a good idea to threaten to commit a person crime as you're coming before the judge. Miss Gillette, Bobby Coe just joined us from the jail, and he was using MF and F words, threatening to slap someone who apparently is a jailer but was on duty when he allegedly set off a fire alarm. And that's why I was suggesting to him that that was not a good way to start the docket.
Well, I guess we'll get a copy of today's court hearing for Mr. Cole's new charges of criminal threat.
All right, Mr. Coe, let's take up your case. We're on the record in 2024 CR 170, State of Kansas versus Bobby Joe Coe, County Attorney Jill Gillette for the state, defendant Bobby Coe in person, in custody, and pro se. Mr. Coe, you're charged in one count. It's called, let me double check let me look at the official language. You're charged with unlawful request for emergency service assistance. The state is alleging that on or about the 12th day of September 2024, in Greenwood County, state of Kansas, Bobby Joe Coe did then and there, contrary to the statutes of the state of Kansas, unlawfully and knowingly make a request for emergency fire assistance, knowing at the time of such request there is no reasonable ground for assistance. To wit, caused fire alarm to go off in jail, raising concern for jail staff. And this is a Class A non-person misdemeanor. If convicted, you could serve, in addition to whatever your sentence remains now on whatever charge you're serving, another 12 months and pay a fine up to $2,500. Who has your attorney been that most often that's been appointed?
William McLennan.
You don't have any more felonies pending?
No, ma'am, I do not.
He had Shannon Cooper on his misdemeanors before, and then she was the contract attorney, so he would need Mr. McClendon now.
He was the one that I had for my city stuff, Jill.
What about his what about our public defender contract with Richard Paw?
I don't know why there might be a conflict with Mr. Paw, but
Okay.
Bobby.
Is he out of the same office as Chris Pate?
Yes.
Yeah.
Chris Pate was my ex-wife's attorney on our child case.
Okay. All right. Very good.
That's for CR 99, October 15th at 3:30. So he's already here in court on 3:30 with Mr. McClendon on 10/15. It's the case he's custody on.
Wait a minute. Say that again, please.
He has a case October 15th 2024 3:30 with Mr. McClendon as his attorney on the misdemeanor docket.
It's for what I'm sitting in jail on
What?
now.
I thought you were on a show cause right now. I thought you'd had your probation revoked.
No,
No?
ma'am.
No,
No,
He
it's
had-
for, it was driving while habitual. You sentenced me to 90 to 180 days.
he has a review of the time that you gave him.
Okay, so he is serving a sentence, but he's
Yeah.
set for review to see if he can get it modified. All right, and now he's got this charge of
This isn't helping,
reporting a fire. Say that again, Ms. Gillette.
helping getting a modification.
Yeah, I know.
All right. So we will appoint William McClendon as your attorney, if he can take the case, and we will set this for October 15th at 3:30, at which time apparently you and Mr. McClendon have a motion for me to reconsider or to grant you parole for the case that you've been revoked on.
I haven't been revoked. It's just, there
That
was
was
no,
the original sentence, all right?
yes,
Rephrase that. Now, let me rephrase that so we have a clear understanding. You are serving a sentence, and you and your attorney have filed a motion for me to consider letting you out early, reducing your sentence, paroling you, or something of that sort.
yes, ma'am.
And now you've got this new charge, and then you came in here threatening to slap one of the deputies and.
Allegedly.
You, allegedly, I heard that with my, you better not make me a witness in your case, Mr. Coe.
I apologize. I was
You're gonna be
just,
in trouble.
I was just a little irritated. You know what I mean?
You kind of are a witness, Judge, because you saw it. So I'm gonna have to order the tape of today.
Now, you ordered the tape and you called the deputy there, but if I have to come testify in your case, Mr. Coe, I'm not gonna be very happy with you.
Well, I'll make sure that that does not happen, ma'am.
All right, I don't know how you're gonna do that, but
I don't either.
you and Mr. McClendon can work that out with Miss Gillette, but anyway, we have to do what we have to do.
Yes, ma'am.
And I won't find you in contempt for talking like that in court, but you understand, we don't.
Yes, I greatly apologize, and I hope that I do not get files charged. I do not need any more trouble. I was a little irritated and aggravated.
All right. Anything further, Ms. Gillette, on this matter?
No.
I apologize, Miss Gillette.
All right, better apologize to that deputy. She didn't need to be hearing that either.
I apologize, Mayla.
All right, you can go at this time, Mr.
All right, thank you. You guys have a wonderful day.
Your Honor, do we have a bond on this case?
Yeah, do we have a,
Well, he's not going anywhere because I think he's serving a year, but
no, I'm serving 6 months.
oh, 6 months, excuse me. All right. But we can set one. I'm thinking 5,000 cash or surety. Let's make that his bond.
Okay.
Thank you, guys.
You're welcome.
Have a good day.
The only person he should have been irritated with is himself.
Now, I believe we have just one left on the docket with 2 cases. We'll be on the record now in 2024 CR 99 and 24 CR 170, each captioned State of Kansas versus Bobby Joe Coe. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
William McClendon for the defendant, Bobby Coe, who appears from the Greenwood County Jail.
Now, counsel, this third case that was filed in which I was named as an endorsed as a witness, apparently, you've set that in front of, was it Judge Crum?
I think Judge Ricky kept it for himself.
Oh, Judge Ricky.
Judge Ricky,
Okay.
yes, Your Honor.
Well, I don't know if anyone addressed these remaining cases with him as a possibility of keeping them together or not.
He kept the 170 case too, I believe. Am
He
I
kept
right,
the
Jill?
170?
That's what I have in my notes.
Correct. So he has 2 new cases. The only thing that's on for today is the review of, this is the 3-month review of him being in custody. You gave him 6 months in jail. And you said you would review it today to see if he could get out basically for good behavior. But while he's been in jail, he's racked up 2 new cases.
Well, and he was also supposed to have his mom drive him to treatment and complete inpatient. Did that happen? No.
I do not believe so,
Your Honor, the sheriff for the sheriff's department would not let that happen.
Probably because of the new charges.
No, this was the new charges.
It was prior to that, Your Honor.
All right,
Yeah.
Mr. McClendon, you're hired to speak for him. Why don't you do that? What's going on? Why did he not do treatment?
I know that the sheriff wasn't wanting to let him out because that's not really a valid reason for release in his mind, I guess. I remember I'd emailed back and forth, and I don't think it was ever specifically put in a court order. And so, in a journal entry, that is. I could be wrong, but I don't recall one. And
It's in the journal entry.
Well, the journal entry was kind of choppy. It said mom, he could be released to mom, but I don't think it said why or something. Yeah, when I went back and looked at that, I thought, well, we should have probably worded that a little more specifically, but
that was the reason why the sheriff was apprehensive about it. And I know, and I'll be honest with you, this is in July, Your Honor, and I don't remember quite exactly what happened, and it might have fell through the cracks, but
well, the sheriff doesn't usually overturn my orders, so I wonder if there's some misunderstanding. In fact, I've never known him to overturn one of them. Mr. Coe, what do you want to add on your own behalf?
Your Honor, I'm currently on Senate Bill 123 and I'm required to do drug treatment and report to my community corrections officer before this was prior to me being sentenced. You know what I mean?
Well, that's why I was going to let you do it. But
You know what I mean? And so when I come to jail and I talked to the sheriff, and the sheriff said that he wasn't going to allow me to do it. He wasn't going to allow my mom to drive me back and forth to treatment in El Dorado.
Well, I thought it was inpatient treatment. No, I wasn't going to let you drive back and forth to treatment.
It was outpatient.
that's what it was.
It's outpatient.
Okay, well,
That's what it was.
the issue. There
Yeah.
is the issue. I understood that you were going to be inpatient. Yeah, I can understand why no sheriff would want to let an inmate just willy-nilly run in and out. That would defeat the whole purpose of being in jail. So, but since you've been in there, you have gotten into some new charges that you may or may not be guilty of. That'll be for Judge Rickey to decide. But at this time, I'm going to go ahead and just let you finish your sentence that I originally gave you, because I see no justification for cutting it in half. So that's my order at this time. And nothing further. We'll be in recess. Thank you all.
Does she testify?
These matters are pending in the District Court of Greenwood County, Kansas, both State of Kansas versus Bobby Coe. Case numbers 2024 CR 170, 24 CR 174. Jill Gillette appears as Greenwood County Attorney. William McClendon is Defense Counsel. Mr. Coe appears from Greenwood County Jail's Zoom location. This matter is set for status on both of these cases. I hope progress has been made since our last appearance on October the 15th. Mr. McClendon, what is the announcement you make at this time regarding these cases?
Your Honor, we'll be waiving preliminary hearing pursuant to a plea deal.
Okay, and obviously that's in 24 CR 174, the criminal threat case, correct?
Yes, Judge. And it's a global plea resolution, misdemeanor plea.
All right. There's not going to be a felony plea entered in the 174 case?
No, Judge.
All right. All right. Mr. Coe, you currently have a felony case pending, but it's court's understanding that you will not be seeking to have a preliminary hearing in that case. Is that correct?
Yes, Your Honor.
All right. And that there's apparently your intention to plead to misdemeanors today?
Yes, Your Honor.
All right. Let's get some clarification on this. What is the plea agreement that's been reached?
Judge, he'll be pleading no contest or guilty, Mr. McClendon.
No contest.
He'll be pleading no contest to amended count 1 in 24 CR 174, disorderly conduct using fighting words. The fighting words talking about wanting to slap and hit, or I don't remember what all the threats were. Deputy Blake Fisher is the deputy, put him in lockdown on the night he pulled the fire alarm. He made that threat during Zoom, and it was recorded on a Zoom video call. The Judge Webster was the presiding judge and heard and would have been a witness to. That was during the Zoom call on September 17th, 2024. And there was a jailer in the room that he was making the threatening comments towards and wanting to hurt Deputy Blake Fisher. Then the other case is the 2024 CR 170 false alarm. Mr. Coe ended up pulling the fire alarm in the jail, having to cause an investigation into the alarm. And he caused the officers to all have to respond back or have calls in and such. So requesting emergency services when they're—
Okay, just a moment. Is it contemplated that he's pleading to that charge as set forth in the charging document?
Yes, Your Honor.
Okay, you may continue.
So that's unlawful request for emergency service assistance, causing concern about pulling a fire alarm in the jail when there's no fire present. And that's 24 CR 170.
All right. Mr. Coe, I'll address you personally again. It's the court's understanding that you would resolve the 174 case by pleading to an amended charge of disorderly conduct, a Class C misdemeanor offense, punishable by up to a $500 fine and up to 30 days in the county jail. Do you understand that?
Yes, Your Honor.
This court's understanding you're also going to plead no contest and accept conviction for unlawful request for emergency service assistance, a Class A non-person misdemeanor, which would be punishable by up to 1 year in the county jail and up to a $2,500 fine or both. Do you understand that?
Yes, Your Honor.
The court will note that from the prosecutor's earlier remarks made to the court that there is a factual basis for each offense. So I'll ask the defendant, Mr. Coe, do you now freely, knowingly, and voluntarily enter pleas of no contest and accept conviction for disorderly conduct in the 174 case and unlawful request for emergency service assistance, a Class A misdemeanor, in the 170 case?
Yes, Your Honor.
All right. The court finds that the no contest plea is a free and voluntary act on the defendant's part in both cases. There's a factual basis in each case. And then the court has made the defendant aware of the possible penalties as to each of the two cases. Court will accept the defendant's no contest pleas and find him convicted of the amended charge of disorderly conduct in 24 CR 174. Also find him, pursuant to acceptance of his no contest plea, convicted of unlawful request for emergency service assistance, a Class A misdemeanor, in case number 24 CR 170. Since these are misdemeanors, defendants pleading to will proceed to sentencing at this time. What are the prosecutor's recommendations regarding an appropriate sentence?
Your Honor, on both of the charges, my recommendation is they run concurrent to each other, but consecutive to his current sentence he is in on. He is currently in custody serving a 6-month sentence, and he's over halfway into it on a
Okay,
case.
what's the case number there?
Case number 24 CR 99.
All right.
He is serving the 6 months on that case. It's a driving while suspended case is what he pled to. So there's approximately 2.5 months to go on that case. My recommendation is going to be an underlying a 30-day sentence on each case to run concurrent at the end of his current 6-month sentence, extending his current jail term by 30 days If he had pled to the felony, it would have a special sentencing rule that they're consecutive, but they are misdemeanors. So the court does have that as a discretion. Instead of it being a mandatory presumption that they be consecutive because they're committed while incarcerated. Court costs. I don't know if the court's going to put any counsel fee on him since he has spent the last 6. I don't know if he's on one of the work crews or not making any money, but court cost, booking fee. I don't know what other fees to ask for other than those two, and to have you review attorney's fees.
Very well then, Mr. McClendon, your recommendations regarding an appropriate sentence on each of these 2 cases?
Miss Gillette outlined what my understanding to the plea deal was, and I'd ask for the same recommendation, 30 days consecutive to his current sentence, but ran concurrent together.
All right. How much are your fees and the representation of this client on each of these 2 cases, Mr. McClendon?
In the 170 case, they are currently at 30, and the 174 case, they are at 144, but I think I have some adjusting to do to split the time on both of those cases.
All right, very well. Thank you.
So they're about 200 in total, not counting today.
All right, Mr. Coe, at this time, the court will address you personally and ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court.
No, Your Honor.
Very well. We'll pronounce sentence first on case number 24 CR 174 for the conviction for disorderly conduct, a Class C misdemeanor. The court will not impose a fine on that particular charge, but will order the defendant to serve 30 days in the Greenwood County Jail. Regarding case number 24 CR 174 for the conviction of unlawful request for emergency service assistance, a Class A misdemeanor, court will order the defendant to serve 30 days in the Greenwood County Jail. We'll run the time on these 2 cases as recommended concurrently with one another, but will run the 30 days consecutively to the sentence currently being served in case number 24 CR 99. Certainly it appears appropriate to this court, Mr. Coe, that you serve additional time because of the rather unnecessary and inappropriate crimes that you committed while in custody. Essentially, improper words, let's say, to an officer, and apparently pulling this fire alarm stunt. You're just complicating your own life by acting up while you're in jail, and I hope you realize that now.
Yes, Your Honor.
Essentially, because he's going to serve the time out, he's going to flatten his time on each of these 2 cases once he's out of jail after that additional 30 days. Court will be assessing misdemeanor docket fees in each of those 2 cases and booking and fingerprint fees on these 2 cases. In regards to the case originally charged as criminal threat, I trust that this is a bids appointment. Court will be assessing to the defendant a $100 bids application fee, but will waive legal fees. And because of his incarcerated status, the court will also waive attorney fees in the misdemeanor case. Now, you're going to owe this money when you get out, Mr. Coe. It's not going to go away. It's you've got 60 days after your release date to pay both cases in full. Any remaining balances that you haven't paid, I'll authorize to be sent to collections at that point.
Okay.
So the plan is you've got 60 days from time of release to pay in full. It won't be sent to collections until after the end of that 60-day period, but any remainder will.
Yes, Your Honor.
So I would just recommend you just hustle and get these cases paid off to avoid complications and further fees.
Okay.
All right. I'm looking at my notes. Ms. Gillette, is there anything further that the court needs to address on either one of these cases?
I can't think of anything else, Your Honor. Thank you.
All right, Mr. McClendon, anything further we need to address?
Not at this time, Judge.
You have any questions about the court sentencing orders, Mr. Coe?
No, Your Honor.
I hope that you can be successful for the remaining balance of your stay in jail and just quietly do your time in compliance with the rules of the jail.
Yes, Your Honor.
All right. There's nothing further then. The Bobby Coe matters will currently be in recess, and this meeting may be ended for all. At this
Thank
time.
you.
Be safe, be well, sleep sweet, and much love.